had taken Mr. Roger Sizemore into his confidence, and told him about the Attorney General's Office investigation, the entire investigation. The entire investigation was revealed by the Commonwealth Attorney to a man who was arrested for DUI drugs and has a drug problem. You will hear a lot of different testimony in this case. You will hear testimony on my behalf from the Drug Court Board. The Harlan Drug Court is run by a board. A lot of judges do it on their own. They have them the Commonwealth Attorney, and they just do it the way they want to. When I came into office, I kept 3 of the board members from the previous judge because I was not interested in just yes men or women in there to do what I wanted done. I wanted real people who cared about people who wanted people off drugs. This board voted in regard to John Clinton. They voted to create the position because our program had grown. We didn't just have a drug court program in name, we had a drug court program for purpose. We, as a board, were tired of seeing children born shaken, addicted to Oxycontin. We, as a board, were tired of seeing people lose their kids, lose their lives, lose their homes. We were tired of that. We wanted to help, and the drug court was the mechanism for that purpose. Our drug court grew to almost 200 people. Our last graduation was about 59 people, and it did wonders. It's not perfect. It didn't give everybody all the answers, and anybody that fools the drug court understands that. But Mr. Clem was a vital part of that drug court program. This, and you'll hear the testimony of how well he's done, of the community service programs. And he gave an option for the male testers. In other words, we had male participants. You'll hear the testimony. They needed somebody to help the male participants. We had 2 female workers. The way drug testing is done, I don't have to explain it to you, it really creates a problem. It was a way to help. You'll hear testimony that the drug court had begged AOC in Frankfurt to give us another worker. In fact, they took one of our workers during this time period. We did not want to tell people no. We wanted to help. And that's what you'll hear from. You'll hear from Tom Bacini. He is the regional director for the Unite program, a fine fellow. You'll hear him testify about how John Flynn came to be. Now, if you're looking at the drug court policy, you will see the policy that tells that a judge can meet and have meetings to promote courts, drug courts, wherever that may be. You'll hear that, you'll see that. You'll see how he came to be. You'll hear testimony from me that I have 2 positions in my office that are non-merit positions, and I could have hired anybody I wanted to. And either one of those were even a cousin. And that was hard work to find somebody in Harlan County that wasn't a cousin. So my point to you is, if you use the standard that they're going to use in this hearing. In regard to the playground, you all have been in this from day one. You've looked at this thing. You know, it's not like this is your first blush at this. I've never admitted from day one, I've never denied from day one that I helped as a parent to raise money for a playground for elementary school. Not once have I ever denied that. And everything I've ever filed, I've admitted that from day one. Now, you'll hear testimony from me again in regard to that. But I do want you to understand a couple of things. The assertion that I did that for political purposes really hurts me. That's one of the worst things about this case. There's the sign on that playground of who made donations. My name is not on this sign, nor will I allow my name to be put in any way, shape, or form. You'll hear me testify that I dug a hole really deep. You'll hear me testify that I poured concrete extra thick in there for the poles for this playground. And you'll hear that I poured the rubber mulch. We went the extra mile and got the rubber mulch. So when the little fellas fell, they wouldn't get hurt. We poured it about 12 inches deep. I did that. And I told you from day one I did that. The reason I did that, because I never would have dreamed as a young judge there would be anything wrong with raising funds. And you'll hear me testify about that. Raising funds for children to have a playground, the poorest kids in the county. That's a fact. I got letters like these all the time as a new judge. You'll see me introduce this into the record on Supreme Court letterhead saying, "Dear Judge Alred, I'm writing to ask you to help protect the integrity of the justice system and the safety of Kentucky citizens by contacting your legislative representatives." I come in as a young judge. I follow the training that I think I'm supposed to. But I get a Supreme Court letterhead letters like this all the time telling me to raise money for the prosecution and defense. In regard to Mr. James F. Howard, the civil case of Pollard v. Howard, one thing that Mr. Mando probably won't tell you when he puts his witnesses on, but I will when I testify and introduce the file. That case was filed in 2007, and the civil case was pending for over 2 years before he filed a motion for me to recuse. I ruled on numerous motions in that case for 2 years. It is my belief that the state of judicial ethics does not require about the essential need for funding and resources to support the prosecution and defense criminal cases, are in that case. Please contact the state legislatures as soon as possible. Frankly, real fraud away from Congress. That's what I've already consequences. Not addressing it. I don't know this any prosecution against that requires a judge to recuse because somebody was against them in the election. Circuit judges are elected. District judges are elected. Court of Appeals judges are elected. Is that the standard we have to go by? If someone says they were against us in the election, do we recuse? If that be the case, that's the end of the electoral process for judges, because anytime you wanted to get rid of a judge, simply state, I was against you in the election. Mr. Mando made a point of that, and you'll hear me testify that that didn't appear to be the reason. He also left out, you'll hear me testify, that in that civil case, James F. Howard, in his motion for me to recuse, never mentioned the criminal case. He never mentioned it as a grounds for me to recuse. In the criminal case, it's my position, you'll hear me testify, that I had signed an agreed order of dismissal against Mr. Howard. It was signed before there was even an arraignment in the case. You will hear me testify that I did notify the state police that I had received complaints. It was my belief that if I did not notify law enforcement, that I might have a potential Canon 1 violation. The special grand jury was convened because it was requested of me. And you'll hear me testify to that. Henry S. Johnson, who was on stage with his recorded interview, says that he agreed with it. You'll hear me testify that was requested of me. You'll hear a whole different story from what the sheriff's office is going to tell you about the first time I ever saw any evidence in this case. You'll hear me testify that I was at the sheriff's office, signing either a search warrant or arrest warrant, which I did. I made myself available. This is during the time period when my district judge had cancer surgery and was recovering and had all kinds of different issues. And I helped out. You'll hear me testify that they advised me of the case on Joe Bridges. You'll hear testimony that you didn't have to beg or plead with Sheriff Lickford to find out about the investigation on the judge executive. He was all too happy to tell people about it. The only reason that I watched one of the videotapes, but it was the only one they had at the time, the way I understand it now, was because, and you're going to be testifying, the sheriff had indicated to me they might be coming for a search warrant or an arrest warrant. And my quote was, you better have a lot of evidence if you come asking for a search warrant or arrest warrant on a judge executive. The sheriff was all too happy to show me right there in his office. And you'll hear testimony from me about something that didn't really ring a bell to me until recently when I was preparing for this case. You ever wondered why a sheriff would have a biotape on his hard drive in his office? I used to be a prosecutor. I used to be a defense attorney. You'll hear me testify. That's the strangest thing I've ever heard of, now that I think about it. Usually the biotape's on a little disc with the case file. In Mr. Lickford's case, he had that on his hard drive in his office. Which goes into what I know now. It was basically a smorgasbord. Have you ever wondered why a sheriff would have a biotape on his hard drive in his office? I know that there's a lot here. But I'll close it this way. Before I do that, though, in regard to the substitute teacher, it was my belief that as a circuit judge, I had discretion to set bond conditions. I actually went to the circuit judge's training not too long ago, where I was told that judges use their discretion to set bond conditions. Ms. Teschen's case was a fraud case. School teachers are in a position of trust. In my opinion, the highest trust. Ms. Teshin was not a permanently hired teacher. She was a substitute school teacher. There were a lot of allegations made that I told her she couldn't go to the school or anything of that nature, which proved to be totally false. I set her bond condition, and made a bond condition for anybody who was on family bond, not to substitute teach till your family charges were resolved. Now, Mr. Mando's version of how it was brought to the principal's attention is different than mine. In passing one day at school, I had advised him that that individual was under indictment. And that was the end of it. At that point, what they did was their business. In fact, I even consulted, the board attorney was in court, and I even consulted with him before when I set the bond. And he agreed. There should not be people calling substitute teachers under felony indictment. You will hear testimony that if you have a felony indictment, you can't even ride the bus with your kids on a field trip. I had no axe to grind with Ms. Teshin. You ever have? Had an axe to grind with Ms. Teshin. You didn't know who she was until a lot of this came up. So this will be my testimony. You heard Mr. Mando say, oh, one other thing too. In regard to the doctors, in that case, this case will unfold and you'll see the truth. The real problem with the doctors in this case was not that Judge Alred was kind of be heavy-handed and do all these things. You'll see the evidence in this case show that there was a hearing to dismiss the case for lack of jurisdiction, that I overruled the motion for lack of jurisdiction. I think Mr. Coleman even asked a question about how do y'all have jurisdiction in a case like this, in one of my preliminaries. Judge Coleman asked. My point is, that was already decided. If I told, and you'll hear me testify about that didn't happen, if I told Henry Johnson, get all the money on dismissal for lack of jurisdiction, I missed my chance because I overruled the motion. Also, I didn't get all the bond money either because I released over $200,000 of bond money. Did you ever wonder why the bond was so high too? I think that's something you need to know. You'll hear me testify that one of the defendants had already been sentenced to penitentiary for murder. He murdered his wife, he murdered his mother-in-law. He had a passport for a foreign country. Extremely fly risk. But you hear the testimony, that's just not true. You will find out that when the trouble started for me as a circuit judge is when Bill Ball of the Chaplains Corps, who is the political branch in the Harlan County Sheriff's Department, nothing more, is a political arm of the Sheriff's Office that's trying to build a political machine. And you will hear testimony about this political machine. When this judge did the right thing and refused to be strong-armed by a sheriff and a Commonwealth attorney to allow $50,000 of donated funds from a criminal defendant to end up in the sheriff's coffers, that's when trouble happened for me. And the sheriff told me, and I'll testify about it, he told me the Chaplains Corps will be coming after you. He told me. And I've been dealing with this ever since. I did the right thing. I've never once tried to profit myself or my family as a circuit judge, and you'll hear me testify to that. In fact, my family suffered because of it. They can't do certain things. In fact, you'll hear me testify that your investigator, Gene Weaver, went to the elementary school with my daughter, and Mr. Mando's wrong, my sister doesn't work at the elementary school, so sister-in-law. But it's a good thing when a man in a briefcase and a two-piece suit shows up at school, and you bring your teacher out of class to talk about your brother's kids and your children. My kids don't go there anymore. My brother's kids don't go there anymore. That's not what this is about. That's not what Judicial Conduct Commission should be about. That's what happened in my case. Now, briefly, I want to close with this on my opening statement. Just a second. You'll hear the testimony here today. You'll hear testimony from my side that talks about a lot of different things. You'll hear a lot of allegations made, but this sums it up best, what happened in this case. The very thing that the preamble to the application of the Code of Judicial Conduct says. The canons and sections are rules of reason. They should be applied consistent with constitutional requirements, statutes, other court rules, and decisional law, in the context of all relevant circumstances, including the varying degrees of responsibility and administrative functions of different levels of court. The code is to be construed so as not to impinge on the essential discretion of judges in making judicial decisions. The code is designed to provide guidance to judges and candidates for office and provide a structure for regulating conduct through disciplinary agencies. It is not designed or intended as a basis for civil liability or criminal prosecution. Furthermore, the purpose of the code would be subverted if the code were invoked by lawyers for mere tactical advantage in a proceeding. And that's what's happened to me. Since this has been going on, you dismiss those charges on pretrial drug testing. Every circuit judge in the state of Kentucky gets the pretrial drug test except for me. I honored you all's concerns about that and stopped it. The Commonwealth attorneys used it to his tactical advantage. Defense attorneys have used it to their tactical advantage. Mr. Melvin is here, used it to his tactical advantage. I've been looking over my shoulder for the last 2 years. That is not what this is about. Not one thing in all this investigation pointed that Judge Russell Alred put a dime of money in his pocket or put money in anybody else's pocket. And the thing that tells you everything you should know about this when it comes out in the evidence is that 2 of the charges, which you dismissed, and I thank you because that's the right thing to do. 2 you didn't dismiss. You overruled my motion to dismiss. And that was in regard to the John Clem allegations. That was in regard to the 17 pages of documents that I told Mr. Mando and Mr. Kelly about. 17 pages of documents were denied me. And it'll be my proof in this hearing, when I testify, that the reason they were denied me is because of this 4th agreed order of extension that said we had to have everything resolved by February 21st, 2011, when it was over. Can you explain to me how 17 pages of documents obtained in February by Gene Weaver from the Kurt Stout, the jailer at the Harlan County Detention Center, never made it to me until July of 2011, after I'd already been charged, and those records were used? Which would you choose if you knew you made a mistake? I even wondered if the commission even knew that Mr. Weaver had done the charges that you all charged me with. And there's the reason why. Because if they sent them to me, you hear me testify about that, it would have been barred by the time I got my responses came back. It's my position, and I'll testify, that they made an intentional decision not to turn those over to me. They could have a Supreme Court Rule 4.170 subsection 4 violation, which you could say is inadvertently left off, or you could be barred by the time. Which would you choose if you knew you made a mistake? I even wondered if the commission even knew that Mr. Weaver had gone back down there to get those records. I even wondered if they had permission to do that. It's interesting to note that on his mileage reimbursements, he didn't even put it on his mileage reimbursements. That'll be my testimony in this. I can assure you, everything that I did, I've admitted to you all from day one. I've not been dishonest with you. It's in my intention to prove that. Just hear it. God bless you, and thank you for your time.
Thank you, Judge Alred. Y'all need a break. Let's take 10 minutes. We'll be back at 11:45 to start with the first witness.